We are joined now by Scott Hechinger, Senior Staff Attorney and Director of Policy at Brooklyn Defender Services. Scott, thank you for being here.
So glad to be here. We do have a lot to talk about.
We have a lot to talk about, and I'm really excited to talk to you. I've wanted to talk to you for a really long time outside of Twitter. So just for our viewers, can you tell us a little bit about what you do, what your day-to-day looks like? I think that it is not only fascinating and interesting, but so important, and I think our viewers would like to know.
I work for Brooklyn Defender Services. I'm a public defender. We represent almost half of everyone arrested in Brooklyn. So depending on the mood of the NYPD, that's somewhere in the range of 30 to 40,000 people every year. We also have an immigration practice. We also have family defense practice. But what do I do every day? I represent people who cannot afford an attorney. There's a Sixth Amendment right to counsel in criminal proceedings where you're facing jail time, and I enforce that constitutional right. So the mornings I'm in court every day. While I'm waiting often for my case to be called, I'm either writing motions or drawing attention to the everyday injustices that I see on Twitter and other modes of communication. And then when I get back from court in the afternoons, I'm writing my motions, I'm negotiating on the phone, but I'm also leading policy efforts for the organization. So trying to raise up the experiences and the perspective and what we witness as frontline practitioners every day and the voices of our clients and the people who we serve to drive systemic change outside of court in a way that other people wouldn't be able to do.
And so touching on two of those kind of points that you just made, like what you see every day and the aspect of that you see something that no one else really would be able to see, would be able to explain. They don't have that perspective. And when we were kind of setting up this interview and talking, you said something to me that it did stick with me. You said, you mentioned that public defenders are overlooked as experts. And I thought that I totally believe you, and it makes no sense. Can you break down why we fail at that?
Well, first of all, I do believe, thank you for pointing it out, that we're uniquely positioned as public defenders, as frontline practitioners, whether you're practicing in criminal court, family court, immigration court, to help lead the fight to end mass punishment. We're in court every day. We see how these laws, practices intersect to drive mass punishment, to hurt the people who we serve in their communities, mostly Black, brown, and immigrant communities. We also have unique relationships with the people who we serve, and so why have we not been utilized? Why have we not been come to more often, as you ask? And there's two things. I mean, historically, we're just not trusted. We're not trusted by the people who we serve in their communities. We're seen as cogs in the wheel, for better or not for better, for worse, but with some legitimacy, based on history. But that's changing. But also, lawmakers view us as folks who just want to get people out of jail. We don't have any good ideas. But what we really have are ideas that can make the system fairer, more cost efficient, and actually make the public safer at the same time. And so we're seeing changes right now as public defenders, as frontline practitioners are getting more savvy on social media, are building really important, as we are Brooklyn Defender Services around the country, coalitions and collaborations and partnerships with grassroots organizations and leaders. And the people who we serve, not just to use their stories to highlight injustices, but to really partner with them and give them and provide them with agency as partners in this advocacy effort. We're starting to see changes. We saw that this past year in New York with major wins with public defender involved campaigns on ending cash bail for the majority of crimes in New York and changing the law, finally bringing our discovery laws in line with the rest of the country. Up until January 2020, the prosecutors are entitled by law in New York to withhold most evidence, most information until after, not just the day of trial, after the first juror is sworn. And so those were major changes that happened because lawmakers started to listen to us. And not just to us, listen to us, the communities that we serve and directly impacted people.
Let's talk about mandatory minimum sentencing, because you wrote a piece in the New York Times and it starts off saying they drastically limit accountability for those with the power to take away a person's liberty. Break that down for our viewers.
So just an example of something that public defenders, me included, see every day that's not obvious to the outside. So first of all, what are mandatory minimums? Mandatory minimums are laws that make it illegal for judges to sentence something post-conviction to anything less than a certain period of time in prison. It transfers a lot of, or all discretion to the prosecutors, and prosecutors use the threat of these mandatory minimums where the judge could be your mom, your best friend, your son, your anyone that loves you, and they wouldn't be able to sentence you to anything less. And because of that, what prosecutors will do is they'll say, oh, okay, the mandatory minimum is 3.5 years. We'll offer you 2 before trial, or offer you probation before trial. And most people take the offer, whether they're guilty or innocent, whether they've been stopped and frisked unconstitutionally or not. And that's a major reason why 95% of convictions come from guilty pleas, not trial. But there's more than the loss of trial, and this is what the point I was bringing up. These guilty pleas and the coercion that comes with these guilty pleas happens before pretrial hearings where people would be able to challenge their unconstitutional searches and seizures, violations of their rights by police. And so in addition to getting rid of the jury trial, mandatory minimums also contribute to not just insulating police violence and police misconduct, but perpetuating, because it sends the message. It's not just the individual cases. Officers know that when they make an arrest, they're likely never to have to take the stand and face cross-examination by a public defender. With misdemeanors, more than half the cases resolve on the same day of arraignments with the police before they even start their next shift. That bad stop and frisk is closed up. They're never going to be questioned. And the guilty plea also closes off any possibility of a federal civil rights lawsuit. So the point that I made is, look, obviously, police departments' failure to hold their own officers accountable. Daniel Pantaleo, the murderer of Eric Garner, is a perfect example. It took 5 years in international pressure and the ruling of a NYPD judge to finally get the NYPD to fire him. They rightfully take a lot of the blame for this crisis of impunity in police officers, but we can't ignore mandatory minimums as a part of this.
So kind of staying on the topic of sentencing, I want to talk about some high profile cases because everyone I think is still talking about Amber Geiger in Dallas, Texas. And she was just sentenced to 10 years in prison for killing Botham Jean. A lot of people were angry, right? And felt like she deserved a much harsher punishment, a much longer sentencing. Someone died, right? But I saw a lot of criminal justice activists kind of taking a different stance, and it opened my mind because I think initially I was one of those people, you're so frustrated and I didn't think she was gonna be found guilty even. And then it's like 10 years, is that enough? But I guess when I think about justice and maybe where we should be, maybe I should be thinking, and we all should be thinking about those things differently. Where do you stand on that?
I think we should be thinking about them differently. But let me first point out that outrage is totally normal. It's okay. We should be outraged. I was outraged, and I have to say that you know, the Giulianis and the Trump administration these kind of high profile cases of leniency. They do test the public defender medal, and my kind of not wanting to see people go to jail. It does test me. But here's the thing that I know as a public defender and as someone who's also a student of history and particularly criminal justice history. Any single time that we call as a society for greater harshness, that greater harshness has the largest impact on the majority of the people who are coming into the system. And who's the majority of the people being brought into the system? That's Black and Latinx communities only living in certain neighborhoods. And so ordinarily it's pro-carceral forces like police and prosecutors that are using kind of high profile cases and really weaponizing tragedy to further mass incarceration. This was the story of the 60s, 70s, 80s, and 90s, calling for harshness. That's when mandatory minimums came into effect. Pretrial detention expanded. The criminalization of everything happened. But there's our allies in this fight, and folks who are obviously well-meaning and are close friends of mine are also starting to call for harshness. And what I would just caution, what I do caution, is that we should be turning our outrage into different avenues instead of calling for greater harshness, knowing that the people who are going to be most affected are the people who are the most marginalized, and not the wealthy, not the white privileged few who get these lenient sentences. We should be calling for more mercy and leniency for all. So when Manafort, for example, was sentenced to close to 7 years, I pointed out that I had a client of mine who was facing the same amount of time for stealing a bunch of quarters from a residential laundry room. And the point was not that Manafort should be sentenced to more. I just wish my clients received the same kind of individualized justice. When Harvey Weinstein had $1 million bail set with a prearranged bail package, was able to get out before he really went even in, and was able to be out pre-trial, presumed innocent, able to work collaboratively with his attorneys for maximum impact. I wasn't mad at his treatment. That's how bail is supposed to work. It's supposed to serve as an incentive, not a punishment. So my call there is for my clients to receive the same treatment, for the bail statute to work for them too. And I think with the Amber Geiger case, I think we should all want and wish for that same kind of leniency and mercy. And frankly, 10 years is a long time. It's hard to even
I'm so glad you said that.
It's hard to even call that lenient. You really cannot overstate. Look,
yes.
I've never been to jail.
Our brains are warped.
You can't overstate the impact of a day in jail, let alone 2 days, let alone a week, a year, let alone 10 years.
We are forgetting that 10 years in prison is a harsh punishment because we live under kind of this criminal justice system that actually sentences people to 190 years in prison. Why? Exactly. And we're forgetting.
We're forgetting, but it's not just that it's harsh. Mm-hmm. It's not just that 10 years is a long period of time. It also just doesn't work in any conceivable rationale. Uh-huh. It doesn't make the person who's incarcerated better. It actually, all the data is suggesting, far from deterrence, it actually makes people more likely to commit crimes when they're released. Now, the populations of roughly Seattle or Boston are released from prison every single year. And we're releasing them with no tools to be able to reintegrate into society. But what we're also doing is subjecting them to the horrors of punishment in American jails, which are criminogenic. What do I mean by criminogenic? Well, Danielle Surratt, in her amazing book, Until We Reckon, I highly recommend it. And she's been really at the forefront of restorative justice, has talked about how the same characteristics of prison, which are isolation, shame, lack of economic opportunity, and violence itself, are the primary drivers of violence. So we're throwing a solution at violence that actually is the driver of violence. And the last thing I'll say about prison is it's not just about individual fairness. It's not just about public safety. We also know that prison is very, very bad at healing the trauma of survivors of crime. Mm-hmm. And I think actually the Amber Geiger case is a really good example of that, where you had, and he was, I think, pilloried really wrongly, but you had the brother of the victim, of Amber Geiger's victim, saying that he wished she didn't have to go to jail. And the concept of restorative justice is what's going to put all the parties in the best position to both feel healed and feel accountable. And I don't think prison does that. And I think the data and all the studies should suggest the same. And I think we're getting to a point where people are starting to understand that.
Scott Hechinger, I have so many more things that I want to talk to you about. So we're going to have to have you back. I know we're going to have you back. Thank you so much for joining us here this evening.
Really nice to see you.
Like what you see? Click the subscribe button below and don't forget to ring the bell to never miss another video from the Young Turks.